I'm Richard Uslan. For over 30 years, I've been an experienced criminal and municipal court defense attorney, and I want to speak to you about your drug arrest in Clinton, because an experienced defense attorney is going to approach your defense in two major ways. The first is to challenge the seizure that led to you being stopped by the police, whether it was walking around in Clinton or driving around in Clinton. And the second is going to be whether the police had a reasonable basis, without a warrant, to search you or your vehicle, which led to the recovery of what are claimed to be illegal drugs in your possession. The police, in the event of a warrantless search and seizure, need probable cause. For that, an experienced defense attorney is going to have to know the law as to search and seizure. I've been reviewing these laws for over 30 years. I review the police reports carefully to establish issues that we can raise by way of what's called a motion to suppress evidence that give us the opportunity to cross-examine police officers before trial as to whether or not there was probable cause for the seizure or a reasonable basis to search you without a warrant. Recently, in the hundreds of cases I review every year, I've noticed a pattern. There's a case decided by our Supreme Court called State versus Peña-Flores. What that case says is that in the event of a warrantless search and seizure, not just do the police need a reasonable basis to believe that criminality was afoot, that there were drugs in your vehicle, they also need exigent circumstances in order to be able to go in to that car without a warrant and recover the drugs. A way they're trying to circumvent this is by waving a consent form in your face, and from your own experience you may already know that there were claims that you're going to be waiting several hours if you don't consent while they get a telephonic warrant from a judge, or that you're going to be there for an inordinate amount of time while you're waiting for them to bring the canine dogs to come sniff out your car. I know how to challenge this evidence, and if we're successful, the drugs won't be admitted into evidence, and you're going to be found not guilty of possession of drugs. Another way to challenge the evidence in this case is to examine the police reports and see whether the police and prosecution can establish a chain of custody of that evidence. What do I mean by that? The police are going to establish, or try to establish, that they obtained the drugs from you or your vehicle. Those drugs are then placed in a police evidence locker. They're going to be removed from that locker and brought down to the state police laboratory, where they're going to presumably be tested. From there, the drugs are going back to the police department, and from there, they're going to be brought to the courtroom, presumably, to use as evidence in the prosecution. Bear in mind, for a drug possession case, the prosecution must have those drugs they're claiming you possessed to introduce into evidence. If we can establish a weakness or a break in the link of this chain of custody that I've described, those drugs aren't going to be admitted into evidence, and you're going to be found not guilty of possession. An experienced attorney knows what to look for in these reports, knows what reports to request in the first place, knows what your rights are. I've been doing this for over 30 years, and I prosecuted at the county and municipal court level hundreds of drug cases. So I know not only what the prosecution has to prove, but I know what potential weaknesses the prosecution may have in their case to use to your advantage. Please call me if you have any more questions. I look forward to speaking and helping you.